And controversial, Rocco Galati isn't your average advocate. He's a kind of legal David known for tangling with Goliath-sized courtroom opponents. His peers seem to approve, electing him just last week to the bench that oversees them. His latest case may be his most contentious of his entire career.
Galati has successfully sued the government before. Last year, when Prime Minister Stephen Harper nominated Quebec Judge Marc Nadon to the Supreme Court, Galati stepped in, saying the move broke the rules. No one expected him to win. Galati surprised them. His latest lawsuit targets the very role of the Bank of Canada. The bank was set up in 1935 in the wake of the Great Depression to provide a means for settling international accounts. The lawsuit claims the bank would also provide interest-free loans to government to finance infrastructure investments like the St. Lawrence Seaway and the Trans-Canada Highway. The case argues that in 1974, the bank stopped providing interest-free loans to government and suggests the move was made to join the International Bank of Settlements, a kind of central bank of central banks. On behalf of his clients, Galati argues that from then on, private banks became government's lender, a change he says contravened the act that established the central bank and was therefore unconstitutional. His client, the Committee on Monetary and Economic Reform, or COMER, is suing to force the bank to make those interest-free loans to government again. The bank hasn't filed a statement of defense but says the case is frivolous. Still, Galati is pressing ahead. When I caught up with Rocco Galati recently, I wanted to know why it was important to bring the case now.
Well, my clients felt it was important. We initiated the claim in 2011. They felt it was important in the face of the financial sector meltdown in 2008, the banking meltdown, and the drastic reduction and elimination of human capital infrastructure such as healthcare, universities, and basically the stuff that the Bank of Canada from 1938 to 1974 funded, which put us head and shoulders above most of the G8 countries in terms of financial stability and sustainable social services.
So if you are successful, what would happen after that? What's the next step?
If successful, the next step would be another request to the Minister of Finance for interest-free loans for a particular infrastructure project or funding. And if the answer is no, we judicially review that on the legal test of reasonableness, which the courts have the jurisdiction to review.
Because what you're suggesting is that various levels of government, including provincial, could access interest-free loans, one would expect that the provinces might be quite interested in this case, even if the federal government isn't inherently interested in it. Why are they not more?
Well, they're not, because they've agreed as of 1974 to be bound by the orders and dictates of the Bank of International Settlements in Basel, Switzerland, which is in effect a central bank for central banks. Now, the only difference and problem is that Canada, most people don't know, is the only G8 country to have a public bank. There's a difference between a central bank and a public bank. Anybody can have a central bank. We do. Ours is public. The U.S. central bank is a private bank, the Federal Reserve. The Bank of England is a private bank. So all the European banks are private. So you have foreign private bankers dictating to a public civil servant and Minister of Justice what to do in this regard of a law from Parliament.
Just make the distinction between private and public, because we don't think of the Federal Reserve as private. We think of it as an arm of that government.
No, it's not. People have shares in that bank. It's like the Bank of Montreal or the TD Bank. It's a private bank. It's huge, but it's a private bank. They're beholden to their shareholders at the end of the day. So it's a private bank like any other.
So the notion is that because of all of those central banks' participation in the Bank of International Settlements, they are then manipulating what our public bank can do.
Correct. They're dictating what our public bank can do. The net effect of that is this. We effectively, through the Bank of Canada, have relinquished our sovereignty to private banking interests. We are saying to private individuals abroad, you can control our public bank, and we'll follow your dictates.
That Bank of International Settlements, though, of course, is designed to create stability globally. Central banks coordinate activities to some extent, but with that in mind, not with any kind of private gain for those banks in mind.
Well, look, that's not true what you just said. At the end of the day, that organization is there to secure the profitability of the central banks. we don't have necessarily a profit motive because we are a public bank. Those other central banks are private banks. So at the end of the day, profit is still the bottom line. It doesn't matter how you dress the chocolate. It's what's inside that counts. You know, I get a lot of people saying, you know, these are conspiracy theorists. And my answer often is, well, first of all, you have to look at the issue, look at the law. And often I respond to people by saying, if you think my clients or myself are conspiracy theorists, then you must be a coincidence theorist. But the thing of it is that conspiracy is an indictable criminal code offense in Canada for good reason, because since Julius Caesar, conspiracies happen every day. They don't have to be nefarious. They can be very civil and in the open, but it's just a conspiracy. A conspiracy simply is an agreement to effect a certain end. It doesn't have to be criminal. It doesn't have to be nefarious. But so to say that they're conspiring, well, they're sitting down and they're agreeing to certain things and giving orders to our bank, which they shouldn't do under our Constitution.
Just argue for me or help me understand the counter argument here. If the government, the federal government, could avoid paying massive amounts of interest on debt and borrow interest-free from the central bank, why wouldn't it choose to do that? What's the argument it would advance to say, no, that's the wrong thing to do?
Well, on the face of it, it says because the banking community, quote, the banking community would not like it. Well, that's saying foreign private bankers don't like it, and my answer to that is too bad. It's the law. Second of all, the Minister of Finance has repeatedly given this mantra that it creates inflation, which is nonsense and borne out by the fact that in 2008, when there was the financial collapse of the banks, the Obama administration gave $800 billion to the Federal Reserve. The Federal Reserve simply created $800 billion, interest-free, and bailed out the banks. We here, through the Bank of Canada, gave three banks $60 billion and secretly assumed their toxic debt of $160 billion through the defaulted CHMC mortgages. So none of that bailing out at 0% interest of the banks caused any inflation. So why should it cause inflation when it never did historically from 1938 to 1974?
So assume that things go as you would like, and that ultimately you can say to the finance minister, you must abide by this ruling, and he doesn't. Does this become a protracted legal fight around trying to change behaviors from people who don't want to borrow interest-free?
Well, most struggles to enforce the law are. I mean, often, you know, I've had cases that have gone 12 years successfully at the end of the day because the government simply wants to ignore the law. It's not a new thing, the governments ignore the law. I mean, but that's the system we have. When they do, the only people who can force them to abide by the law are the courts. And so,
what appealed to you about this case? What was it that, because it's sort of arcane, it's very complicated, but why did you say, yes, this is a fight I want to take on?
Well, it appealed to me because although it's arcane in the sense that, you know, anybody who knows something about economic theory and economic history may think, oh, this is arcane. This is the new flavor of the day. We don't use interest-free money. But it wasn't arcane for me because it's in the law. Whether it's arcane on the street is one thing, but the law says they can and do have the power to do this. The bank was created for that purpose, and now they've handed over the functioning of the bank with respect to currency and interest positions and policy to foreign private bankers, which causes two constitutional problems. One, under our Constitution, a government and the executive cannot refuse to govern. They have to apply the law. But here, they've given the application of the law surreptitiously to foreign private bankers. Well, that's unconstitutional. You can't relinquish sovereignty.
ROCCO Galati's lawsuit against the Bank of Canada is the latest in a long line of legal battles he's brought against the federal government. But taking on those controversial cases comes with a price.
One of Galati's biggest breakthroughs came in 1999. He represented Mavis Baker, a domestic worker who had lived illegally in Canada for many years. The government had decided to deport her. Up until then, it did not have to disclose why. Galati lost the deportation appeal, but he struck a blow for democracy when the court agreed with him. Government should be publicly accountable for its decisions, a landmark ruling that changed government forever. No one is underestimating Galati in his latest fight over the Bank of Canada's business. His cases can seem improbable, but Galati has a long history of coming from nowhere to win. In the second part of our conversation, I wanted to know more about what motivates him and why he thinks